Well, I see it's 1:30, so we're going to get started because we have a lot on our agenda for today. Welcome and thank you all for joining us today on Wednesday, April 28th, and it's 1:30 in the afternoon. You're joining us for another one of Homeline's 90-minute COVID-19 webinars where we discuss tenant landlord issues during the pandemic. And we've got an exciting presentation for you today. Joining me today are a number of other staff members at Homeline. As always, we have Mike Vra, Managing Attorney and Tenant Hotline Director at Homeline. I'm Eric Hauge, Executive Director at Homeline. And then today we're joined by two staff, Leah DeGrazia, who is a fellow with the SAKE's Public Interest Residency Program at Homeline and a tenant advocate on our hotline. And she'll be leading this discussion about some analysis of eviction cases throughout the past year. And joining Leah also and joining us is Homeline housing attorney Andrea Palumbo, who will be discussing some information about this presentation as well. But before we get to really the details of the presentation and more detailed introductions, a couple pieces of logistical information that we share every time we have one of these seminars. So again, just a reminder of what Homeline is. We're a statewide nonprofit organization. Our main program is a free and confidential legal hotline that renters can call and get advice about their situation. And we've advised over 260 renter households throughout the state since opening in the early 90s. We advise folks in English, Spanish, Somali, and Hmong languages. And we have a staff of over 20, including housing attorneys, tenant advocates, as well as tenant organizers and policy staff. This is our information about our tenant hotline, how you can reach it if you are a renter. Again, these seminars we provide some general legal information, but not legal advice. If you are a renter and have a question about your situation now during the pandemic, or really any time about a legal question, a practical question about your tenancy, contact our hotline, and there's the information about how to call or email. Before we get into the logistics for today, want to share that we have a number of upcoming webinars. We've been doing these seminars for over a year, since April of last year, mid-April of last year. And we're kind of on we had gone to about a every 2-week schedule, but in May, there's a number of things coming up. So we've got a few extra ones. So 2 weeks from today, on the 12th of May, we'll just have another regular 90-minute session where we'll talk about any news, any updates in the eviction suspension, as well as potential discussions at the Minnesota State Legislature about potential off-ramp or ending of the suspension. We have a special session set up on the 18th, not at our regular time. It's a Tuesday, the 18th, and this is for a really select. It's designed for a select group of stakeholders. We'll be discussing, in partnership with the Minnesota Engagement on Shelter and Housing organization, homeless prevention planning for the end of the eviction moratorium. So this is really a workshop designed for family homeless prevention and assistance program stakeholders, who who you are if you are, and if you don't, it may not be relevant to you. But I am going to, in a bit, post links to the registration as well as some more information about each of these sessions in the chat. And then lastly, we will have another one just a week after our May 12th one, the following Wednesday, because that week in May, on the 17th of May, is the end of Minnesota State Legislative Session. And there have been a number of discussions about an off-ramp or an end to the eviction suspension. So it's possible that we may have more information about that week. So we're holding another session on Wednesday, the 19th, to cover those details if there are updates. Again, I'll post links to the registration for those in the chat. For today, just a reminder, this is a webinar format, so you're muted, and if you do have any technical issues or questions, the best thing to do is submit those over the Q&A system in Zoom, or if you have comments over the chat. We are applying for 1.5 credits, just general CLE credits for this session, and attendees for today will get an email follow-up once that is approved, if and that's approved. We have a large crowd today, a large audience. This was a follow-up to our most popular session from last year in October, when we had Leah and Andrea on to discuss sort of the first 5 or 6 months of the suspension and some of the data on that. So we got a lot of questions submitted in advance. We're probably going to mainly focus on questions that came in advance. The presentation is somewhat lengthy today, but we'll have a little bit of time to cover some of those questions at the end. Some of those questions might get answered as Andrea goes through updates on the eviction suspension at the beginning of the session. These slides for today and a recording will be posted on our website in the same place where you registered, and we'll send out those materials, that information on that once it's posted. All right, so before I hand it over to Mike, one last important thing. Since our last session, which was on April 14th, 2 big things happened. The eviction suspension was extended for another month, and Andrea is going to talk about that in a moment. But then last week, the new COVID emergency rental assistance program, which is using federal dollars that the state received, was launched on April 20th, I believe. This is the information. I'll put some more information in the chat and some links, but basically renthelpmn.org is the place for tenants to go to apply, and landlords can go there to get information about how they can get ready and receive funds through that program. Tenants that need assistance with their application or have questions should dial 211, and they can get assistance over the phone. So with that, I'll hand it over to Mike Braw, Managing Attorney and Hotline Director.
Thanks, Eric. Those of you who are huge Mike fans aren't going to get much of me today. I'm going to be introducing some people that are going to be talking about almost everything. I'll be asking some clarifying questions, but yeah, not much Mike Braw, Managing Attorney today. Instead, first, we're going to hear from Andrea Palumbo. She is a staff housing attorney here at Homeline, has been with Homeline for over 2.5 years. And in that short time, she has become, well, she's the person who deals with more evictions in our office than anybody else. She has advised over 1,275 renters in Minnesota throughout the state on their rights concerning evictions specifically. She's also advised many others on several other topics, but she's going to talk to start about the current state of the state and federal moratoria. Andrea. I think you're on mute.
There we go. What I want to do is kind of give a little bit of the groundwork and a sense of where we are with the Minnesota peacetime emergency and the eviction moratorium. As Eric mentioned, the peacetime emergency has been extended and it is in effect until May 14th. And Minnesota's eviction moratorium tracks with the peacetime emergency. So that is also in effect until May 14th, 2021. The peacetime emergency has been extended. It is in effect for 30 days at a time. So it is entirely possible it could get extended again past the 14th. And the eviction moratorium has been dealt with in a series of executive orders. There have been 3, and the one that is controlling right now is Executive Order 2079. And if you hear us talk about 2079 or EO 2079, we are referring to the most current executive order that addresses the qualifications in the eviction moratorium. Now, the governor's authority to establish a peacetime emergency and an eviction moratorium has been challenged, and there have been a line of state cases. There was actually a case that a decision that was released from the Court of Appeals on Monday, an unpublished decision dealing with a challenge to the governor's authority to impose a peacetime emergency. But for the most part, these cases have really, they haven't been successful. Obviously, the emergency and the moratorium have been held up. There's been a federal case as well. I have the site in the, I should say I have the title in the slide, the Heights Apartment LLC, and that was decided. The case was dismissed, and it was I should say it was a case brought by a group of landlords, and they sought summary judgment and a temporary injunction, and the case was actually dismissed. So that case is going up on appeal to the 8th Circuit. So there's kind of where the case law is sitting right now. Next slide. Now for federal protection, way back in 2020, the coronavirus aid, relief, and economic security, the CARES Act was passed, and that had a sunset date. So that really isn't in the picture right now. Most of its protections have basically ended with the sunset period, except for that one requirement for the property owner to give the tenant a 30-day notice that they are filing an eviction. And this is important because in Hennepin and Ramsay County, both counties require a landlord to indicate as part of the eviction complaint that they have complied with all of the requirements of the CARES Act. So that's kind of where that sits now, except for the 30-day notice. That's really not in the picture. There is also an order that was issued in September 2020 under during the Trump administration, which was a protection against eviction for non-payment of rent only. And the initial order, as it says, was issued in September through the end of the year. And a second order was enacted earlier this month through June 30th. This does not apply to Minnesota right now because if a state has stricter protections against eviction like Minnesota has, the CDC order does not apply. In a way, it is kind of a backstop to the Minnesota eviction moratorium, though. If and when the Minnesota moratorium ends, the CDC order could be it's going to come into play, and it's going to be much more important. And this has also been challenged in various lawsuits, but right now it is the law, and it is the protection in other states, but not in Minnesota. Okay, next slide. So the big question, actually there's a lot of big questions, but one question that we get a lot is, when are evictions going to be filed again? And we really don't know at this point. We do know that the peacetime emergency can't go on forever, and the moratorium is going to end at some point. There are some proposals in the Minnesota State Legislature right now for coming to an for bringing the moratorium to an end, rather. There's a House proposal, there's a Senate proposal, and most likely what's going to come out of those is going to be a compromise. And what we're hoping to see is, instead of kind of opening the tap full blast on evictions, ideally we'd like to see kind of a ramp down, a gradual a gradual trickle of cases, as it were. And we also know that district courts, and specifically housing courts, are making preparations for the resumption of eviction filings and looking at how they can stagger filings and really work out calendars so that basically the courts can handle the cases once they get filed. Next slide. So I am now going to turn things over to,
Yeah.
actually, Leah, this is your piece.
This is Leah right now. Yeah, I'll jump back in here, Andrea. And there's a couple technical questions that were submitted in the Q&A, by the way. Those of you that have a question, the Q&A is the best way to submit that. Andrea, if you could try to answer those in the chat. Just pose the question and then you can answer it in the chat and people can see the answers that you have
Sure.
there. All right, so now we're going to go into some very deep dive research stuff. Leah DeGrazia is going to take over for most of the rest of this time that we have together. Leah is a third-year law student, which is the last day we can say that about you, right? Today's your last day of your third year of law school.
That's right.
That's congratulations.
Thank you.
Well, not yet. You have to get through to 4 o'clock, right? You said 4 o'clock is when your day is over.
That's
Okay.
right. Yeah.
So it's premature now. Leah's been with us for about a year. She got a fellowship through the Sakes Foundation, I want to say. Is it a foundation?
That's a great question. I'm actually not sure.
The Sakes Fellowship Program. Anyhow, she's been working with us for, like I said, the better part of a year. And she has done a ton of research. She's going to talk about how much research she did to get ready for today's speech. So she could talk today about this year that we're examining, an entire calendar year where evictions were substantially limited here in Minnesota. So Leah, thanks again for your year working with us, and take it away.
All right. Thank you, Mike. Can we go to the next slide? So like Andrea said, we have done, this is our second part of 2 webinars. The first one, we looked at the number of evictions filed between March and October for 7 months. And then the second for October through March 22nd for the second half of the year. We looked at both those in the metro area and then those in greater Minnesota. And we found that there were approximately 1,246 evictions filed over the past year, with a slightly higher number filed in the past 5 months than were filed in the first 7 months of the moratorium. All right,
so that's counterintuitive, right? I mean,
yes,
there's more in 5 months than there were in the 7 months. Any thoughts on why?
I think it is definitely because of Executive Order 2079. The first couple months of the moratorium didn't have as many exceptions to filing. And I think there was a lot of hesitation to try to even get into court. There was a lot of uncertainty as to what could be filed, what couldn't be filed. And so now it seems like there is an upswing on people filing for not only those exceptions, but then also just trying to get things into court more than I think they were for the first part of the year.
Okay.
Can we move on to the next slide? So this is from our last webinar. This is the first set of metro area cases. Unsurprisingly, Hennepin and Ramsay County had the highest number. And there were 303 metro cases for that first 7-month period. Next slide, please. Hennepin has about 8% more filings now for the second half, or not half, but second set of evictions. But again, the distribution was about what we would have expected for metro filings.
I do want to jump in for a second. Ramsay filings for the second set of metro cases that we looked at are a little lower. And that is interesting. Like Leah was just saying, Hennepin and Ramsay really account for the bulk of the metro eviction cases, but Ramsay's are lower. I do know that in Ramsay and Hennepin County, there is a specific procedure where cases are filed and then they're reviewed before they're placed on a calendar. And that could be accounting for some of Ramsay's numbers, that just in that review that we are seeing cases end up on the calendar they're taking longer and it's a slower process.
Right. So Eric, if you could just toggle back and forth between these the last slide and then this slide. Look at Ramsay and Hennepin County. So Ramsay, 30%, Hennepin County, 43%. That's the first set. Hennepin goes up to 52 almost. Ramsay's down to 23. It's almost an 8% swing in both cases. That Hennepin is comprising a much higher percentage of the evictions throughout the state, which again, we have theories on, but what we're really trying to do with this information is share the data that we could find. And Andrea, you were going to cover the next few slides until we got up to the methodology point.
Right,
so
right.
I'll let you jump back in. Sorry about that.
No problem. So here's the cases. Here's the first group of cases, March through October 2020 for Greater Minnesota. And as you can see, or you might have to really lean in close to your monitor, not surprisingly, the counties with the greatest number of cases are St. Louis County, Olmsted County, Clay County. Those are where we have larger cities. So that's what was happening at the beginning of the cases we looked at. And on the next slide, you can see that there was definitely an increase in filings in Greater Minnesota. And St. Louis County is the highest, but there are some significant jumps here in Clay County. That's the county where Moorhead is. Douglas County, that's Alexandria is there. Olmsted is quite high, and Stearns. So we are kind of calling back to our earlier slide. We are seeing more cases getting filed in the second part of the data we're looking at, kind of the later part of the moratorium. So Leah, this one's you.
So in the next slide, I'm going to get into a bit of what our methodology was, but real quick, before that, there are 16 counties that have no cases filed for the full 12-month period. There were some that only had evictions filed in the first set of evictions, some that had like 1 or 2 in the second, but there were 16 where absolutely no evictions were filed for this entire past year. Unsurprisingly, these are not metro. They are, I believe, like more rural, less populated areas. So it wasn't super shocking, but there are some places where no evictions are filed. Yeah.
And again, this isn't a calendar year we're talking about. It's when the moratorium was instituted back in March of last year through March of this year. So a full 12-month period, but not January 1st to December 31.
Yes. All right. Now to switch gears a little bit, I'm going to focus only on the second half, the second set of evictions from October 17th through March 22nd. So for this set of evictions, I personally spent at least 40 hours finding and reviewing every single publicly available record for these eviction cases filed between October and March. I was able to do this by finding different case numbers from both the evictions filing data extract that Homeline gets from the Minnesota courts, and also going through each county in MinSys, which is the Minnesota Court Integration Services website, where you can find some information on what cases have been filed around the state, not just for housing, but for all sorts of different things that go through the courts. From those two, I was able to get a master list of case file numbers. There were 686 cases that I was able to find from the extract and from MinSys. I took each one of those cases and looked at them individually in the Minnesota Court Records Online, which is a great new tool that is available now to Minnesotans, where you can look at court records online, and all of this information is publicly available.
So Micro, when did that come online? Do you know?
Fairly recently. We did not have access to that for the first set of evictions.
Back in October, right?
Correct.
Okay.
So this allowed us to dive more deeply into looking specifically at complaints, not just what from Minsus we're able to see some basics, whether somebody had an eviction filed against them, and then whether that eviction went through, whether there was a hearing scheduled, but we weren't able to take a deep dive into the specifics of the evictions. So having Micro and having access to those complaints and judgments and affidavits, police reports, etc., really allowed us to see more clearly what types of evictions are being filed and which ones are resulting in judgments for tenants versus landlords. Of the 686 case numbers that I was able to find, 171 of those records were not available in Micro. That means that they are probably hidden or expunged. Like Andrea touched on briefly, there is a process for determining whether or not an eviction falls under a moratorium exception or not in a lot of places. And so what we are assuming is that, the 171 of these records were likely either solely for non-payment and didn't fall under an exception and therefore are hidden from public record, or they were expunged. And that's just hard to tell. We don't have access to records that were expunged, rightly so. But there were 515 public records that I was able to review. Next slide, please. So of those 515 cases that I was able to dive into, I was specifically looking at which execution under Executive Order 2079 was claimed in the complaint. So basically why they were able to get a hearing, why they were able to get into court. More generally, what the reasons for eviction were and what was detailed in the complaint, and whether non-payment was claimed in conjunction with an exception, and then what the ultimate disposition of the case was. So did it result in an eviction judgment for the landlord? Was it dismissed? Was it dismissed with or without prejudice? Was it settled? Is it still open? Things like that. And what I found was that 187 of the 515 cases, so about 1/3, a little bit less than, about 1/3, claimed multiple exceptions under Executive Order 2079. There were 328 that claimed just one exception. There were 15, so a very small number, where no exception was claimed. These ones got into court by alleging that it wasn't a residential tenancy, there was no tenancy established, they were unauthorized, or they were squatters, something like that. And there were 84 cases that explicitly claimed non-payment of rent as one of the reasons for eviction in conjunction with one of the exceptions. I think next slide, please. So, like I said, the first thing I looked at was which exception was claimed. And just quickly to review, the 4 exceptions enumerated under Executive Order 2079 are that the person being evicted is endangering other tenants or residents, illegal activity that's prohibited under Minnesota Statute 504B 171. Specifically, that's drugs, firearms, prostitution, and stolen property. Significant damage to property, or the landlord or a member of the landlord's family needs to move into that property. And I will go through each one of those in more detail right now.
I just want to mention one thing. The executive order does allow specific exceptions where a landlord can file an eviction, but the one category that's listed here, illegal activity, 504B 171, that that's nothing new. That has been a permitted grounds for eviction from the very beginning of the peacetime emergency. So that's not something that was added out of nowhere, as it were, for the executive order.
I think that's from the early 90s, actually.
Yeah.
That statute, yeah.
Well, and I believe the endangering other tenants was also part of 2014, but then they expanded it to residents and staff as well.
But you're saying that right now, 2079, the one we're under, these are the 4 exceptions. There were others, or there were fewer actually before 2079, yes. But now these are the ones we've been under since August of last year.
Correct.
Yeah.
All right. So, like I said, of these exceptions, of these cases, there were some cases that claimed multiple exceptions, and there were some cases that only had one exception that was claimed. And then there's a very small amount that claimed no exception. What I found very interesting is that the danger to others, 504B, 171, and damage tended to be grouped together, whereas the family member exception was almost even in how many only claimed the family member exception in the complaint. Whereas you can see here, the other 3 largely were paired off with each other. And okay, so endangering others, I believe has been a thing since June, if I'm remembering correctly. But what we saw from the October through March cases is that there were 241 cases that claimed endangerment. 95 of those cases, it was the only reason for eviction. And this was the most common reason for eviction filings. There was a very broad interpretation of what endangerment entailed. And it ended up being very fact dependent. So there were some really clear-cut cases. There are instances of shootings, stabbings, fights, serious threats of bodily harm or sexual assault to staff or other residents. There are some instances of domestic violence. I think there were a couple murders. Things that can't really be debated are dangerous. But there were also several less clear examples, such as quote-unquote verbal threats that then weren't further enumerated in the complaint, just vague discussions of threats. Allegations of things like claiming I'm going to give you COVID or spitting on other people. There were several that claimed that smoking cigarettes in a no-smoking building constitutes endangering others because secondhand smoke is dangerous. And these were all, these cases were all across the board. The endangering others claim varied wildly. And what I found very interesting is that some of these went through and resulted in the eviction judgment in favor of the landlord, and some of them didn't, and it didn't seem to be very consistent. But the majority of them did still result in an eviction or a settlement.
So Leah, when you're reviewing these cases, you're not watching each of these cases live in a Zoom hearing or in person. So you're just looking at papers. And so where do you see the description of what the landlord is alleging? Is it on the eviction complaint itself, or is there a supplemental page, or how is it presented?
Often it is in the complaint itself. There's usually a lot laid out in the complaint itself. There are some instances where additional police reports or affidavits are included in the filings. And so that was where you would get more details. But sometimes it isn't. Sometimes the things like the vague threats that's all it says. It says, why are you there? There'll be a template for the eviction complaint filing, and you can check off certain things. And some of them would just have serious endangerment written down without any further details. Presumably, once there's a hearing, that is fleshed out a bit more. But if it isn't written down, neither that or in the judgment or one of the other publicly available documents, we were not able to look at what those details were.
And we had a question that came in that is relevant to what we're talking about right this moment, which is what about endangering self? There's some more detail there, but it says, what about endangering self? Just glancing at 2079, it says seriously endangers the safety of other residents or the safety of others. So I don't think danger to self is on this list. Is that your reading of it, Andrea and Leah?
That's my take. I haven't seen any complaints that alleged endangering oneself as being grounds for eviction. I'm not sure if you did, Leah.
I didn't see a single one.
Mhm.
Okay. I don't think it fits the executive order
I don't think
either.
it fits.
Yeah.
No.
Okay. All right. Sorry to interrupt there.
No, it's a good question. I think we can move on to the illegal activity. So to reiterate, illegal activity under 504B 171 refers to unlawfully allowing controlled substances in the premises, allowing prostitution or prostitution-related activity, allowing the unlawful use or possession of a firearm, and allowing stolen property or property obtained by robbery in the premises. These cases were pretty cut and dry. If the landlord was able to show evidence of illegal activity, then typically the judgment was in the landlord's favor. It's not a super subjective standard. Either the activity is illegal or it isn't.
Did you see, I'm wondering about the illegal drugs. Did you see a range of illegal drugs involved, or was it really just focusing on one or two, or what kind of drugs did you see people evicted for?
There was a range, and sometimes there was not clarity. Sometimes it just said illegal drug use. Sometimes it said, illegal use of methamphetamines. And so it really varied. And often the ones that were more detailed tended to be paired with other claims, kind of kitchen sinking it, throwing all the details in, whereas the ones that were only relying on 504B 171 would just say something like illegal drug use or stolen property on premises, something like that.
Yeah, from reading the different complaints, that I should say, when someone calls Homeline and they have been served an eviction, I look over the papers, and from reviewing the complaints, what the issue I see the most is pot, that the landlord will say that they smell pot or someone has smelled pot. So just from the complaints and the paperwork I've been reviewing, it seems like that is kind of the default for the illegal activity exception for evictions.
Yeah, I wouldn't say that that's the default. Maybe for default that is being for the people who are calling Homeline, but the smell of pot was certainly not the default or the majority of cases that were claiming illegal activity. There was a wide range of different things, including everything from, felonious possession of a firearm to there's one where there was a meth lab. But then there are instances of just claiming pot. And sometimes those were paired with, actually quite often those were paired with the non-payment cases, which raises some concerns as to whether there actually is illegal activity happening. But there were also instances where the court found that the landlord did not prove, they didn't meet their burden of proof that illegal activity was happening. It is not enough to just allege illegal activity or, allege. There was one that was like alleging the sale of drugs. That wasn't enough, and those cases got dismissed.
Do you see police reports attached to many of these complaints?
Some. Usually the police reports were attached to ones where it was illegal activity in conjunction with endangering others. So things like the meth lab was an explosive hazard. So that's also serious endangerment.
And again, there were evictions for just marijuana possession. It's not required that the tenant has enough for resale or something like that, just possession of marijuana.
Correct.
And another key thing to point out with the statute is that it involves allowing this illegal activity to happen. And it's only specific legal activities listed in the statute.
Yes, and there were some cases where there were no allegations that the tenant themselves was the person doing the illegal activity, and the tenant was nevertheless evicted because they supposedly let somebody onto their property who was possessing drugs or did have an illegal firearm. Although there was one that was dismissed because of the claim in the complaint was that they knew and were friends with a known drug dealer, and that was not sufficient to warrant the eviction.
Your presumption is the judge thought that doesn't really matter unless the drug dealer brought drugs on site.
Yes, and that was explicit in the judgment.
Got it.
All right, should we move on to damage to property? So breach of lease is, in normal times, always something that can be a reason for eviction. But during the moratorium, a material breach of lease can be a significant damage to property. And that only since August, I believe, since damage to property has been one of the reasons.
Oh, in the executive order?
Correct. Yep.
Boy, I'm not sure if that was in an earlier version or not.
I believe it was.
Okay.
I will check on that and let you know.
Well, regardless, there are 205 cases between October and March that claim significant damage to property. From the cases that I looked through, this is far and away the most subjective and fact-dependent of the exceptions. Under half of these cases claimed only damage to property as the sole reason for eviction. Damage to property was often paired with drug use or endangering others. But the thing that really, I guess, swayed which way this eviction judgment would go, like either on the landlord or the tenant's favor, was whether or not the damage was significant. So these cases really varied. There were some complaints that alleged things like holes in the walls, broken windows, bathrooms destroyed, flooring torn up, trees cut down, things that are very difficult to remedy. In these complaints that were more detailed, there was often a monetary estimate for what it would cost to fix the property in the tens of thousands. But there were other cases that alleged significant damage, but the damage was things like there's a scratch on the fridge, or there's a dirty bathroom, they have a dog, they're not allowed to have a dog, but there's no allegation necessarily that the dog has caused any damage to the property itself. The mere fact of having the dog is the significant damage. These cases tended to be dismissed, and there were some very in-depth analyses of what significant meant in these judgments. That being said, there were some cases where the damage wasn't super clear how significant it was, or it didn't allege damage to the same level as some of the others that did go through, often because of tenant default, meaning the tenant didn't come to the eviction hearing, and so the tenant automatically lost the case.
I'm not sure if you kept track of default percentages, but do you have a ballpark?
I would say more than half.
Okay. So a couple things about the damage. First of all, I don't see it in 2073. So I think it was instituted for the first time in August under 2079.
Looks like it, yeah, it looks like that's the case.
As you thought. A couple other questions that have come in, and I'm kind of summarizing a couple, but they're sort of germane to still what we're talking about. Number one is, have you seen any evictions from MPHA, the Minnesota Public Housing Authority, or other subsidized housing agencies? Those have been filed.
Those have been filed, yes.
Okay, and you don't have a list of which topics they filed, but you know that they filed evictions.
I don't have a specific list, but there were several for damage to property.
Okay.
Absolutely.
Okay. Gary is asking, is the writ of recovery being used in these eviction cases? Can it be used? So sort of a procedural question. Are those still possible?
Yes. The writ of recovery was issued in a lot of cases where the landlord prevailed.
Yeah, so the writ of recovery, so everybody knows the same terminology here, a writ of recovery is where a landlord has actually won the eviction case. That's, if a landlord wins an eviction case, that's literally what they win, is this piece of paper that instructs the sheriff to remove the tenant, this writ of recovery. And that doesn't mean they always enforce it or pay to get the actual writ, or pay to enforce it, I should say. But that is the piece of paper that does instruct the sheriff to remove the tenant. So if a landlord wins one of these cases, whether it's during the pandemic or not, then that's what they win, is this court order to the sheriff to remove the tenant through this writ of recovery. Another damage question is, what about non-physical damage to the property? Degradation in value is how it's being described.
Without knowing more details, I mean, I can't really guess. Again, it's very subjective. They would have to show some type of proof that this was caused by the tenant and that it rises to the level of significance.
So there's no dollar number, magic number that you saw where a judge was like, oh, that's under $500. That doesn't matter to me. That's not how they're examining these.
And there were cases that said there's trash piled up and that was deemed a significant damage, and there were cases that said there's trash piled up and that was deemed not significant. And so I think it really comes down to like what type of evidence is presented. Are there photos? Are there affidavits? Who's showing up? Is the tenant represented? Those types of considerations really came
case
into
by
play.
case and
Very
judge by
case by case.
judge.
Yep.
Subjective. Yeah. Okay.
This was an issue at the annual landlord tenant update. What is significant damage to property, and specifically what is significant? And there were three housing referees on the panel, and they each had slightly different takes on the situation. It's very subjective.
I mean, it's an intentionally vague word that the governor put there. If the governor wanted to put a dollar number or a dollar amount that amounted to a significant amount of property damage, then the governor would have put that in there. So it is really left up to the fact finder, which is a judge or a referee in these cases. So
yeah, and I do think that is why a lot of these are paired with danger and illegal activity. All right, and so the final exception under Executive Order 2079 is the family move-in exception. If I can get to the next slide. Thank you. So there were only 66 cases that claimed the family move-in exception. To quickly go over it, this one is a little bit different than the other three. The other three are considered breach of lease claims. The family move-in exception refers to an exception done in August in 2079 explicitly that says if the landlord gives the tenant proper notice under the lease, meaning the lease has, is month to month, they'd have to give a 30-day notice, and then also give a 7-day, and the tenant holds over, and then the landlord gives a 7-day notice of intent to file an eviction, and the tenant continues to hold over, then the landlord can file an eviction stating that their family member needs to move into the property, or the landlord needs to move into the property. This is the only reason right now that landlords are able to give any type of notice to vacate. And it is the only reason that a landlord could file for eviction for holdover, meaning the tenant stayed past when their lease was up. So there were 66 cases across the state that claimed the landlord or family move-in exception. 53 of those cases, so the vast majority, this was the only reason for eviction. A lot of these cases ended up settling. And in these complaints, they often very explicitly laid out why they or their family member needed to move in, but it wasn't always present in the complaints. The executive order explicitly says that the family member needs to be able to move in. It isn't just, I want to have a sewing room, so I need to kick out my roommate. I want to have my brother move in next door to me, but he has stable housing. He doesn't need to move in. Those would not qualify for the family move-in exception. So a number of these were very, very explicit about why that need was there.
I count 13 cases from your numbers here where the landlord listed the family exception plus something else. Is that right?
Yes.
Did that, logically, if I'm a judge, I'm going to think you really want them out for the other reasons. It's not because you need to move in, but you don't have enough proof for that. Did it hurt cases, the landlord's chances appreciably? Do you recall from looking at the files?
Not that I noticed. There really weren't a lot of the family exception ones that were dismissed on their face. The ones that did get dismissed were because of failure to file that 7-day notice of intent to evict. And then a lot of the times those were just refiled and then the tenant got evicted.
Okay.
Or they settled.
Sure.
There was at least, well, I guess it'd be 3 cases, but one landlord where the landlord claimed the same family member needed to move into different properties and named them explicitly in each complaint. But these 3 cases still went through, and I believe at least 2 of them ended up being evicted. So there are some iffier instances of this exception, but it isn't being claimed as often as the other 3. I think we can move on to the next slide.
I've got a quick question.
Yeah.
Did you see any counties that showed a trending in the family move-in exception? So I'm guessing, did you see any counties with increasing numbers that went up in this one area?
Not really. It really varied around the state. There were more in the metro area, but there were several that, were from more rural areas, and they said, I have this house, someone's living here, my daughter can't afford her apartment, she needs to move into this house back home. So it really varied. It was, there wasn't a trend that I noticed.
Okay.
How stretchy was the family member usage? Second cousin, did you ever see that? Or
No,
how
it
far
was
did it go?
usually parents, children, grandchildren were really what I saw.
Because family is not defined in
Nope.
Executive Order 79. Right.
And that was one of the concerns I know when 2079 was initially issued, was like, can your 4th cousin twice removed be considered your family? And I didn't notice any cases that were abusing the type of definition of family.
I do want to clarify, we had a question pop up in the chat about the required notice for filing an eviction, how long that is. And under the Executive Order 2079, before a landlord files an eviction, at least 7 days beforehand, they have to give the tenant a notice of their intent to file an eviction. That is going to be different from any notice period that's included in a tenant's lease or other circumstances. The executive order specifically says that notice of intent to file an eviction has to be in the tenant's hands at least 7 days before the landlord files.
7 days or the notice period, whichever is longer, right?
I haven't seen any interpretations of or the notice period. I have only seen the 7 days.
The notice period comes into play if it is a family move-in exception.
Right.
Yeah.
That's
then
a really
it's
important
the notice
point.
period plus 7.
So the 7-day notice period is true for all of the exceptions. And that is, I get to that in a couple slides, but if somebody is causing serious endangerment, normally they can file for an expedited hearing, and the landlord can still file for an expedited hearing, but they are not supposed to be able to do so until they provide that 7-day notice of intent to evict. The 7-day notice provision is for all of the eviction exceptions. Anything else on the 7-day notice, Mike?
No, sorry, thanks.
Okay. So here I have my dispositions graph. So of the 515 cases that were reviewed, this is what happened in them. The final judgment, or what the result of the eviction action was. 310 of the 515 resulted in what I call eviction judgments. So that means that the landlord prevailed. Of those, over half, and I'm kicking myself for not having the exact number, but over half of those, the tenant didn't come to the hearing. So that is referred to as the tenant defaulted and the landlord automatically won. There were 65 cases of the 515 that were dismissed. Some of those turned around and refiled. Some of them didn't, but they were dismissed for a wide variety of different reasons, but some of those included, not rising to the level of significance for property damage, not giving that 7-day notice, or failing to prove that they gave the 7-day notice. Sometimes they're dismissed for basic administrative things, like you have to properly serve the tenant with the eviction notice before going to court. So there were some cases that were just on their face dismissed. 86 cases settled. There were a lot more cases that initially settled and then the settlement was breached, and so they resulted in an eviction. I counted those cases with the 310 eviction judgments, but there were 86 that I found that had no additional actions after the settlement agreement, meaning it seems like the settlement worked. There are 41 cases. I finished looking at the eviction cases in the beginning of April, or mid-April. There were 41 that were still open that were filed by mid-March. And then there were 13 that I classify as other that were unclear, or they were stayed until after the moratorium but not hidden, which I thought was interesting. There were a couple where the landlord tried to get an IFP to get the filing fee waived, and that was denied. So they haven't moved forward. There was one that was withdrawn expressly because of intervention by the Attorney General, where the Attorney General reached out to the landlord, said, you can't file an eviction for this reason right now, and if you continue to pursue it, we will pursue action against you. So there was one where that was expressly done. There were several that were dismissed because of landlord request as well. So that dismissal often happened because the tenant voluntarily left, and so the landlord no longer needed to pursue the eviction action. I think next slide. So reading 515 complaints, judgments, affidavits, all of that was very interesting, sometimes very heavy, but overall, very interesting. Some of the interesting cases and outcomes that I found were, like we touched on briefly, the dismissal for failure to satisfy the executive order, such as the damage not being significant or being dismissed for some type of lack of evidence. The dismissal for failure to give the 7-day notice. Some of these dismissals waived any future filing fee. So the landlord paid the $300 some to file for eviction, but they failed to give the 7-day notice. The court in their dismissal would say something like, if you file within 14 days proving you have given that 7-day notice, we waive any future filing fee. These often were refiled. Sometimes they were, like I said, dismissed per the plaintiff's request because of Attorney General intervention or because the tenant left. There were some disputed family move-in cases. There were only a couple, but there was the one I talked about briefly where the family member was moving into multiple properties. But then there were a couple where the tenant alleged that this was really a pretext for non-payment and that the family member who was being said that they needed to move into the property didn't actually need to move into the property. Most of these still resulted in eviction judgments in favor of the landlord. But they were interesting to read it seemed like the burden of proof for the family move-in varied what needed to be shown. And interestingly, there were a couple of cases where the eviction was granted, even though that 7-day notice was very obviously not given. There was one where I read the complaint was filed one day and they are talking about significant danger to others or endangerment of others. And the incident claimed happened only 3 days before the eviction was filed. So there's no way they could have given the 7-day notice of intent to file for eviction because it was only a 3-day difference. But the tenant didn't show up to the hearing and they didn't show up to the hearing to raise that defense. And so it did result in an eviction.
I've got a question for you about the Attorney General intervention. What kind of intervention did you see? One really key piece of advice we're giving tenants who are facing an eviction is to contact the Attorney General because there may be some problem with the case or a concern with the case. So when the Attorney General intervened, how did you see that happening?
What I saw was email exchanges, which were actually part of the court documents. And basically there's one case where there was danger alleged. The Attorney General said, I don't think that's actually endangerment. And they went back and forth over email. And finally the landlord said, okay, I withdraw it, but I will file again with more proof.
Yeah, I spoke to a few people who described phone calls and phone conversations that apparently the Attorney General called the landlord and discussed the situation. And I also know at one point, the Attorney General's office was actually sending letters to the court regarding the cases.
Lee, I got a couple questions that came in that are close to what you're talking about right now, so I'm going to ask them here. Wendy asked, do you have any stats on how the outcome varied depending on whether the tenant was represented by an attorney or not?
I don't have any specific statistics. I have general estimates that I can give based on what I read. Sure. And tenants always fare better if they're represented. A lot of tenants ended up prevailing and their defenses were accepted and the case was dismissed. But there was also a very large percentage of tenants who did fall under some type of exception. They had damaged the property. They, did possess an illegal firearm, but they were able to reach a settlement that often included future expungement because they were represented.
Another question is, I would be intrigued to see the racial breakdown of the family exception that led to an eviction. Is that findable in court records somehow?
I am not sure. I don't think it is.
I don't think it is.
They don't collect that in civil cases.
Yeah, they do in criminal cases, but not civil. And even with the criminal cases, it's voluntary.
A couple other questions here. Mary talks about the 3 evictions you found where the landlord used the same family member for all 3 actions, and those tenants were then evicted. Will you, it says, alert the AG office on those, as it seems the landlord didn't follow the order if this happened, or not something you would do?
Me personally?
Well, Homeline, if they know, because you're talking about reviewing files.
Yeah.
Is what you're talking about. So they might not have been our client. We might not have any contact with these folks. It might have just been something you reviewed in a file, right?
Correct.
Yeah.
So.
Yeah, that's about as much as we can say about that. And let's see, I think, did any of the 86 settled cases involve a mediator? Is there a way to tell that from the court records?
I wasn't able to tell, but that's a very good question. Many of them involved having the tenant be represented. So
Can you give examples of settlements that you saw?
A lot of the settlements were tenant will pay the back rent and move out.
Pay the back rent and move out?
And move out.
That's not a very good deal for the tenant in general. Right?
Well, because I mean, it wasn't pay all the back rent up front. It was often like set up some
over
type
time.
of payment plan.
Got it.
And also move out. So those were for cases that, there was non-payment alleged, but then there was usually there had to have been something else that would have gotten them into the court. So if they were to settle, they wanted the money owed via some type of payment plan, but then also often wanted the tenant to leave.
Here's a question about the logistics of evictions, and you've looked at a lot of these filings, and Andrea, you can chime in as well. I had a family member move-in case in Ramsay County where the initial court screening process took an entire month after filing. So the landlord files the case, and the court took a month to decide whether or not to set it on. We didn't receive a summons until the end of that month for a hearing several weeks later. Is that kind of delay common?
I've seen it, yes. I don't want to say it's common, but it is possible.
Well, we have the statutory relaxing of deadlines, right? That's still in effect.
Right.
Because prior to the pandemic, once the case was, I can't remember the wording in the statute, but once the case was processed by the court, then the court was supposed to happen within 14 days, the eviction hearing itself. And that is not a statutory requirement right now because of, it's not just landlord-tenant law, but all kinds of statutes of limitations and court-mandated deadlines are relaxed because of the pandemic, and that one's still in effect.
That being said, there are a lot of cases that got in and out within 14 days. So,
really? Okay.
Yeah, it could be, if there's anything wrong with the filing, if paperwork's missing, or particularly if one party is requesting a fee waiver, IFP, that can definitely slow down the process. But yeah, just as Leah said, there are some cases that move right through, but there are some where the screening process takes quite a long time.
Okay. Let's get on to our...
I'm not sure about the family specific, but I know that the Attorney General is looking into some of the family. I don't know what the process is specifically in the court, but I know the Attorney General does look into a lot of the family move-in ones.
Right.
And so that might make things take longer.
In our office knows housing court really well. We also do a lot of work with tenants that are in conciliation court. And I can tell that in both courts, certainly conciliation court, everything's taking a lot longer than it used to. I think courts are just slowed down. They got to catch up from last year. I don't know when that's going to level back to where it was normal times as well. But let's move on to the last couple of slides, and then we'll take whatever questions we can fit in.
So some takeaways that I got from looking at all of these evictions is that they do continue to be steadily filed across the state. The vast majority of complaints are alleging a 2079 exception, but are not alleging non-payment. A lot of landlords aren't even bothering including it because it's not going to get you into court any faster. There was about 1/5 of the complaints that listed non-payment in addition to some type of exception. 1/3 of the complaints listed 2 or more exceptions. So we are seeing instances of complaints throwing everything they can into it just to get into the court. Tenants losing by default continues to be an issue. This has been a thing before the pandemic. It continues to be an issue. I wish there was a solution, but the fact remains that tenants with representation fared a lot better and secured settlements or dismissals. And overall, the eviction moratorium has prevented a lot of evictions from being filed or judgments being granted. Can we move on to the next slide? So in a normal versus a pandemic year, a typical year sees around 11,000 evictions in the metro area and about 5,000 in greater Minnesota. So about 16,000 evictions a year. This year, from pulling from Minsus and the court documents, I was able to find 1,246 evictions over this 12-month period. So that's it's 8% of a normal year's filing, meaning that there is a very real risk that there are 14 to 15,000 cases just on the back burner still. And it's impossible to know because they are either hidden or they haven't been filed yet. But this is a very, very low number of evictions that have been filed as a direct result of the moratorium.
And there's a couple ways of looking at this. We had a comment in the chat that many more cases weren't filed than were filed, and that's absolutely true. We've seen that borne out. The entire point of the executive order was to keep people housed, and being as far fewer eviction cases have been filed, we are seeing that purpose has been fulfilled. People are staying housed.
Not just housed, but I mean, when this all started, it was not just stay housed, but don't even leave your house, right? I mean, shelter in place was sort of the mantra for months. So yeah, it's the 8% of a normal year's filings, though. That is a remarkable result of the 1 year of moratoria being in place. And this is really just about the state moratoriums because the federal ones haven't really mattered in Minnesota.
That's right.
And we did have a question come in. Are tenants able to appeal an eviction? Yes, they can. We recommend if they're considering doing that they give us a call because it is involved. And there's a couple steps depending on the county and depending on what stage the case is in. But it is possible for a tenant to appeal an eviction. They do need to move fast on it, though. And just as Leah was saying, we don't really know exactly what's going to happen when the moratorium is lifted. The peacetime emergency and the moratorium are going to end at some point. And we are hoping that there will be a wind down of the moratorium rather than just a cliff, as some of us have called it. In terms of cases that are hanging out there, we've seen that 8% of cases that are ordinarily filed, there's generally around 16,000 cases filed every year, and only 8% were filed last year. The remaining 15,000 cases theoretically are out there, plus any additional cases that would have been filed outside of the time period we were looking at. In Hennepin County alone, we had Referee Hotelling speak a few months ago. She's anticipating that there's probably going to be about 4,000 cases in basically waiting for the moratorium to be lifted. And most of those are in Minneapolis. And we know that most of these cases are probably going to be filed at the same time, which is why, in addition to the legislators looking at stepping down the moratorium, courts are looking now at how can they actually schedule these cases, and do they have the personnel to handle them and basically run the housing courts while everything else is happening in court at the same time. So we're really not sure what's going to be happening once the moratorium ends.
Eric, how about you do the wrap up and promo for next time, and then we'll start taking questions and take them as long as we can go, and people can stick around to hear as many of the answers as we can do.
Sounds like a good idea. So yeah, just a reminder. Well, first, we're not going to end just now, but I just want to thank Leah and Andrea a ton for all the work that went into this. That was a significant time investment Leah put into reading 515 case files. So thank you for that. And that's very useful. Before we get to the question, just a reminder, and again, I'll put in the chat links to registration for our future webinars, but we have 3 coming up in the next few weeks. In 2 weeks on May 12th, then we'll just be kind of one of our regular webinars on current status of the eviction suspension and answering questions. And if there are any updates on legislative negotiations about the off-ramp, we'll share on the 12th. We'll do the same a week later on the 19th, Wednesday the 19th. That's the week that session ends at the legislature. So we may have some clear news about what's happening. We may not, we're not sure. And then there's a separate seminar that's really designed for an audience of FHPAP, Family Homeless Prevention and Assistance Program stakeholders. And I'll put that in the chat. That'll be Tuesday the 18th at a different time at 12:30. Also on our website, there's a COVID tab, and we have plenty of resources, FAQs, etc. A reminder that the statewide COVID-19 emergency rental assistance program is live. You can, as a renter, you can apply right now if you go to renthelpmn.org or call 211. And that's what I have right now. So we'll go to Q&A.
Let's dive into the questions. Yeah, always my favorite time of these sessions because we never are sure what people are going to ask. We're going to alternate between Andrea and Leah answering. Andrea, I'm going to start with you. The first question came in from Christine, and Jonathan has just submitted a very similar question. Can a tenant stay after the lease ends May 31, let's say, if the private landlord has indicated they will not renew? So can a landlord use a non-renewal now, or when the moratorium ends? When will they be able to use a non-renewal?
Well, basically, in terms of doing anything to force a tenant to move out, they are, as it stands right now, this may change, but as it stands right now, a landlord cannot use a non-renewal of lease until after the moratorium ends, so after May 14th, and they can only non-renew a lease for the specific reasons in the executive order. But after May 14th, all bets are off as it stands right now. That so long as the proper notice is given, a landlord would be able to have a tenant move out.
And we say May 14th like it's some sort of end date, but we've had 13 end dates already that have come and gone where the landlord has renewed the peacetime emergency. That could happen again. The legislature could come up with a solution. So it really is an unknown, but that's the current end date we're
caveat.
sure of.
Yeah.
Right.
Yeah, that's as it stands now. And we've had some situations where people have thought that they could give a non-renewal now that would actually take effect after the end of the moratorium, and that's not possible.
All right. Let's jump ahead. Leah, gonna send you one from Gary, who's a service provider. Is the eviction process still proceeding, just stopped at the writ of recovery? Does the landlord have to refile if it's stopped before the landlord gets the writ?
I'm not sure I fully understand the question.
I'm not sure either, and without having somebody here to make the conversation, I guess he's saying, let's say the landlord gets the case thrown out procedurally. They didn't do the 7-day notice. Would they have to refile the case? Would they have to repay the $300 filing fee? What have you seen with looking at the files?
Yeah, if the case is thrown out for any reason, then I think that the landlord would likely have to refile. And
you had mentioned
repay.
Some where the court said that they wouldn't have to pay the refiling fee, right?
Those were very explicit, and it was part of the judgment, and it was only because of the failure to provide the 7-day notice.
Got it.
So things that were dismissed, like for bad service, there was not a lot of, I guess, like grace extended to the landlord. There's a procedure. You need to follow it. If you don't, you can repay.
Okay.
In terms of a writ, if a landlord wins a case and a writ is issued, and for whatever reason the case doesn't go any further than that, like the landlord and tenant come to an agreement, if the landlord wants to continue with that case, they don't have to refile the case. They've already won the case. So they can reissue a writ, or depending on the timeline, post the writ that they have.
Yes,
next-
yes, that is an important, I'm sorry, that is an important clarification. The refiling would only be if the case was dismissed. If they'd won, it doesn't apply.
I do want to take a second and clarify my answer. There's a question here. In terms of the Minnesota moratorium, once that ends, assuming the person is being evicted, assuming the landlord wants to give a non-renewal that is permitted under the CDC moratorium, then that would be possible. Because the
CDC federal backstop is
right,
only
the federal
for non-payment of rent.
backstop, yeah, that is in place until June 30th. I should have mentioned that. But there are some differences there, and there are some different procedures that need to be followed. But for the purposes of the Minnesota moratorium, that once that protection ends, we are going to be seeing situations where a landlord could possibly make a tenant move.
Next question is for you again, Andrea. Kamaria, I believe, landlord. She's a service provider. Landlords are finding ways to charge clients for things they normally do not charge for. Is this legal? She doesn't say exactly what the charges are for, but new fees, new amenity costs, whatever they might want to call them.
Yeah. We are getting calls on the hotline about that. Generally, any fee that is charged a tenant has to be specified in the lease, and the amount of the fee and what it's for has to be specified. And we are seeing we're getting calls from people who are telling us that their landlords are telling them that they have to pay an extra fee to pay their rent with a check, something like that, or an extra fee for the utilities, and that is not legal. Any fee has got to be specified in the lease.
Okay. Leah, this is from Brian, an attorney. Are there any potential claims tenants could pursue against landlords that violate the law with respect to eviction? So I think he's talking about the executive order. Would the tenant have a claim against a landlord for that?
I'm not sure. I don't think so. I think right now who is enforcing the executive order would be the Attorney General. Whether they have a specific private right of action for violating the executive order, I don't think there does exist.
Don't think there is.
Nor do I. I think it could be part of a settlement conversation between the Attorney General's office and the landlord, and maybe those have happened. We don't see those settlement agreements, but
True.
that might be one of the solutions or parts of the solutions. But I think you guys are right. This executive order says what it says and who can enforce it. I guess it's a theoretical claim, but I haven't seen a tenant try it.
True. Yeah.
Yeah. Okay. Andrea, and we've gotten this question submitted in the question and answer along with a pre-submitted question, but this one's from Rocky, landlord. The cigarette smoke is affecting other residents. What are the odds of evicting for that? And the person who wrote in during the presentation talked about a building where there's a no smoking clause in the lease. Would that be enough to evict currently during the moratorium? And Andrea, maybe this one's Leah to jump in as well, since she looked at all the files.
This is a tough call. Whenever you're talking about property damage, the property damage has to be to the point that it is a violation of the lease. And a lease will generally say that a lease may be more specific about the level of damage that's required. Cigarette smoke can be a cosmetic issue. It can be something that can be remedied. And that's one thing that the referees really touched on when they were discussing what they considered to be damage or not. Was it permanent? That might be the point where it's significant if it's something that absolutely can't be fixed or can't be remedied. If it's a non-smoking building and you have people smoking, that in and of itself could be a breach of the lease. And the question is going to be, is that causing the safety issue that could reach the point where a person could be evicted? Leah, did you see anything along any cases along those lines?
I saw a couple where the landlord prevailed based on non-smoking claims. They were not for damage, it was for endangerment.
And
so
we
the
got
claim,
a comment from an attorney, Tim, who said that he had won a case like that.
I probably looked at that.
It could very well be. Jumping back to our prior question about whether a tenant could sue, Larry McDonough chimed in saying that he believes there could be a private right of action under Minnesota Statute 8.31. I'm going to go ahead and defer to Larry, as we always do on this program. He might be right about that. I haven't seen one filed yet. And so until we see a successful case, I can't really predict much of anything there. I think the next one's for you, Leah, from Duran, a service provider. During the moratorium, can COVID non-evictable actions be resurrected as grounds for eviction post-moratorium? Okay, so what they're asking is, let's say somebody had a dog and they're not supposed to, not endangering anybody, no significant property damage. Once the moratorium is over, can the landlord evict for that breach?
I mean, do they still have the dog? Is
yeah,
it still a problem?
That would be an ongoing or a continuing breach. The dog might not be the best example. What if they had a giant party in the middle of the pandemic, and 8 months later, the landlord says, I want to kick you out for that giant party? Would they be able to do that?
I mean, I think a lot of it depends on what the off-ramp looks like. I don't know if eviction would be exactly the move, but I think a non-renewal for something like that.
Yeah, I think a non-renewal is much more likely. I also
Yeah.
think that we are probably in the highest percentage of periodic leases ever in Minnesota right now, because I think there were a lot of landlords last summer and to the coming summer, we're in the warm weather months when leases end, where they just say, I'm not going to sign another year with you, but you can stick around month to month because I can't give you a notice of non-renewal or termination. So I think there's a lot more tenants out there that are not in one-year leases than there would be at any other time, certainly in recent memory. But I think you're right. I think a non-renewal would be a much more likely response for the landlord there.
Now, some of the cases that I looked at when people called had instances that happened months and months and months before the case was filed, and it was pretty obvious that it was actually a non-payment case that the landlord was trying to kind of shoehorn into one of the exceptions that was permitted by the executive order. And in those cases, that is something that the judge looks at. Why are you trying to evict someone now for something that happened 6 or 7 months ago?
Sure. Okay. Next one's from Michael at the landlord. Andrea, this is for you. Fire in apartment due to the tenant. A remodel is necessary. I can't do it with the tenant there. What can I do? And this one's you, Andrea.
That's a tough question.
Well, it depends on the damage, right? It might be significant
it depends
property
on,
damage.
is the apartment completely unlivable, or depends on the damage? This is an instance where if the tenant caused the damage and it is significant, to use the magic word again, potentially a landlord could file an eviction for that. A situation like that, and actually for many of the situations that are coming that are coming up in our questions, these possibly could be negotiated, and
Right.
some kind of a settlement could be worked out before the eviction even gets filed. And that's really the purpose of the 7-day notice of intent to file. That
Could be a condemnation too.
Yeah, I was thinking
livable.
that too. It could be a
Sure.
condemnation, but
Yeah. Right.
you could potentially work something out without the landlord having to fork over the $300 odd to file an eviction case.
And just to look at the clock, we're closing in at 3 o'clock right now, but we're going to stick around and answer some more of these questions to help folks. As we mentioned earlier, Leah's not done with school till 4 o'clock, so plenty of time. So she can stick around. The next one is for you, Leah. Lynn asks, well, this is a statement: blight, garbage bags outside, torn apart by animals, electric disconnected by power company for non-payment by tenant. So I think that Lynn is asking, can I evict for these things? Again, we have blight, not sure exactly what that means, garbage bags outside, torn apart by animals, and electric disconnected by power company. Is that enough to get an eviction, do you think?
I mean, in classic lawyer speak, it depends, right? Like that would be a significant damage to property question, and those are the most fact dependent. And so it really comes down to what type of evidence the landlord can bring to the court, and can they show that the damage is significant, and can they show that it was caused by the tenant? And if they can, then it might fall under that exception.
I
If
assume
not,
you've seen cases and or
yes.
decisions where the word significant itself is defined with Webster's dictionary, right?
Yes.
That's a pretty, let's just look at the dictionary. We can't decide what significant means on our own. Let's look it up. Yeah, it really is subjective though. It has to be.
Yeah.
It's just how it's designed.
I've seen cases where judges have gone both ways on that.
Okay.
Yeah.
That type of
Especially like the
damage.
trash and hoarding type issues, I've seen go both ways.
Okay. I'm going to go to some of the questions that have been submitted now from Patrick. This is for you, Andrea. I have 2 apartments with roaches running out under the resident's door. Their places are, all caps, vile, exclamation point. So I think Patrick is arguing, I assume Patrick's the landlord, that the tenants are living so callously to their surroundings that they are, letting the roaches or inviting the roaches to come in through their behavior. What do you think about that one for an eviction?
I'm going to echo Leah. It depends. Obviously, if the situation is as Patrick's describing it, that's a problem. That is not a good situation. Whether or not that is going to rise to the level of significant damage or a hazard to someone's health is going to be the fact question there. I mean, can the landlord show that this damage is happening and it's significant and it is happening because of something that the tenants are doing?
Look, we
There's
still
also,
have, sorry, go ahead.
I saw many cases discussing infestations, especially with roaches, and they often were double filed under significant damage and endangerment, but there is usually also a refusal on behalf of the tenant to allow the landlord to remedy the issue. And so merely having the roaches wasn't what caused the endangerment, it was allowing it to perpetuate. And that was where the significance kind of crossed that line.
So we still have nearly 200 people watching / listening to us right now. So we're going to press on and keep answering as many of these as we can. This one's for you, Leah. About damage to property, this is from Rebecca. Did you see courts delve into whether the damage was willful or malicious? We've seen at least one court order discussing that. So that phrasing comes most prominently in landlord-tenant law from Minnesota Statute 504B.161. We don't like to cite statutes a lot in these sessions, but that's the one that talks about the covenants of habitability. But have you seen that phrasing? Willful, malicious, or irresponsible would be the last part of that phrasing
Definitely.
in court readings. You've seen that?
Yes. I've seen it in the court readings. I've seen it in the complaints, the judgments. Yes. If the damage to, if a damage to a wall is accidental, that might not rise to the level of significance. If it is willful and malicious, I think it is a lot more likely to cross that line. There also were a lot of, there were some negligent fires that I saw, some cases that rose to the level of significance because they likely were going to continue to cause damage. Like they continued to be negligent. And so yes, that language is definitely used.
Okay, Andrea, from Diane, I have a tenant that moved in an unauthorized dog that's considered an aggressive breed. My insurance carrier has indicated this voids my policy and they will cancel me. Can I evict?
Let's see.
Leah, first, have you seen any of those
I was going to
cases?
ask Leah.
Yeah.
We do get calls about this on the hotline too, that something has happened where insurance coverage is involved. And I have seen provisions in leases that say a tenant will not do anything that will cause the insurance premiums or the insurance coverage of the landlord to be revoked.
Leah, have you seen any of these?
Not
Not that
really,
specific thing?
not that specific. So I guess is the question, is merely having the dog the
Right.
danger?
Right.
Or is the claim hinging on the canceling of the insurance? I
Yeah.
feel like canceling of the insurance would be difficult to shoehorn into an exception, personally.
One of the executive order
Yeah.
exceptions, right? Yeah.
I don't think it fits into one of the exceptions unless potentially the dog is dangerous and has actually done something to be a safety hazard.
Okay. Leah, question from Anne. I'm wondering another landlord is selling the property because they can't afford to keep it with non-paying tenants who's overstaying their lease. The purchaser wants to buy it and then they say they need to move in. So we have a change in ownership. The new owner says, I need to move in. Would that be allowable?
Yes, but they have to still give the proper notice to vacate. So say it is a month to month, they would have to give the 30-day notice to vacate and a 7-day notice. And the only person who can actually give that notice would be the new owner who is actually moving in. The
Right,
seller,
so the seller couldn't do that
the
on
seller
behalf of the
cannot do that.
buyer.
Correct.
Right. And that makes sense. I mean, sales fall through at the last second a lot. And so that's a possibility.
So if the sale
yeah.
goes through,
Mhm.
they would have at minimum 37 days with
or
the notice,
longer. I mean, they
or
might be in the
longer.
middle of a 1-year lease, right?
Yeah.
And then the new owner wouldn't have the right to just kick the tenant out under almost every lease we see. Sure. Okay. On to Andrea. This is from Christopher. Oh, interesting. I don't think we've seen this question. Does past rental histories, evictions, damages come into play on any of these cases? So Christopher's asking sort of about tenant screening-ish questions, but would they matter when the judge is analyzing an eviction under one of the exceptions? What do we think?
That is a really interesting question. I have seen complaints where they will say that this landlord has filed evictions against this tenant X number of times, but it's really hard to say how much that plays into the decision that the judge makes. When it comes to kind of in general, if a judge is making a decision, from what I've seen, they only make it on the basis of the case in front of them. They don't, they won't look up the tenant in the court records and see, aha, they've had 10 evictions filed against them. They must be a bad tenant. I'm just going to kick them out. I've never seen anything that indicates they do that. They're just making the decision based on the case in front of them. But if the landlord puts the information in the complaint, then that is going to be something that the judge considers.
How about it, Leah? Have you seen any of those where the landlord would talk about the tenant's past and that's why they should be able to evict now?
I haven't. I also am not sure how like rules of evidence come into play with that. Past bad actions aren't
Sure.
allowable.
Okay. And somebody anonymous posted that the tolling legislation that we talked about, the statute of limitations suspension basically, and the giving courts more time if there was a court imposed deadline, ended on April 15th, which I believe is right, actually. I thought it had been discussed to be renewed, and I haven't checked in on it in the last couple of weeks because it's not exactly front burner stuff for our line of work. So that could be the case that it expired and wasn't. I know it was renewed once this calendar year. So that could be the case. So thank you for pointing that out. But let's go down to, let's see, who's up next? Is it Andrea or Leah?
I think it's me.
Okay, Leah, this is from Gretchen. Do you believe that the recent availability of Rent Help Minnesota funds will influence a possible extension of the emergency order to allow tenants the opportunity to access these funds to pay off outstanding balances? So, political question.
Yeah, that's the current debate right now between the House and the Senate. There are two different off-ramps being proposed, one by the House, one by the Senate, and they take the availability of rental assistance into account in different ways. And so on the DFL side, they are trying to push it out so that more people can avoid having non-payment evictions filed against them, because the understanding is that more people will be able to access that money if we push it out longer. And on the Senate side, they're hoping to just get something in play so that expectations can be understood, because there's a lot of questions currently for everyone. No one really knows what's happening. So it really depends on what type of reconciliation the Senate and House are able to get.
If they get one at all, right?
If they get one at all, exactly. And I do think it's a priority, and it will hopefully come to some type of resolution. I know both the House and the Senate are really trying hard to find some type of solution.
And right now, the moratorium is tied to the peacetime emergency, and the governor has said repeatedly that he is looking at cases and vaccination rates in terms of what he's going to do with the peacetime emergency. So that could also play into the situation. That
Okay, Andrea, this one's
way
for
of saying we don't know.
Right. That's it's well above our pay grade. It's the pay grade of about 4 people in the state, frankly. Okay, Andrea, this is from you. It's anonymous. Can the landlord raise the rent once a lease is up for renewal? This would be more than 90 days from now as a reference point. Assumes proper notice given to a current paying tenant and willingness to accept. Well, the willingness to accept part kind of answers it. If the tenant doesn't fight back, I'm not sure what can happen. But let's say the tenant says, no, I don't want a rent increase. Is there a reason why the landlord can't do that now?
At this point in time, they generally when we're talking about rent increases, they should happen at the end of a lease. This is actually something we have had a healthy debate in our office about, because if you're going to have a rent increase, it's not clear whether that means that you're instituting a new lease, that you're ending a lease and starting a new one. But if a landlord is raising the rent at the end of a renewal period that is after May 14th, after the end of the eviction moratorium, it's very clearly permitted. Before then, it's kind of a hazy area.
Okay. Leah, for the irresponsible or negligent language, what statute is that? So that was the willful, malicious, irresponsible, and I'll just take this one. It's 504B.161 is where you'll find this language. It doesn't use the word negligent in it, whoever anonymous might be. It's willful, malicious, or irresponsible conduct of the tenant is how it refers to that. And I don't remember seeing in the law irresponsible very often, that actual term. You'll see negligent, you'll see reckless, but irresponsible is a pretty uncommon term in the law in general. So 504B.161 is where you'll find that. So Leah, let's go to another anonymous question from a service provider. I'm working with multiple tenants whose building is up for sale or was sold during the pandemic. Do you think that the moratorium new laws will result in fewer small landlords? Is anyone tracking how many housing units are being transferred to large companies?
I think that's a really good question and is definitely a concern. I don't have the answer. I don't know if anyone is tracking that, but it is a worry.
It'd be a hard thing to really pin down. Cities might be able to figure it out by looking at licenses. And so it's findable stuff, but it's not something that's really easy to find quickly with a couple of clicks of the mouse.
Mm-hmm.
All right, Andrea. Oh, this is from Diane, clarifying my previous dog question. I think you had the dog question before. The upper tenant has children and are afraid the dog will attack. They don't use the yard because the dog is outside. The dog has also destroyed grass and sod. Okay, so I think Diane is trying to pin down a seriously endangering others by scaring the children, plus destruction of property, some sod. What do you think? Is that enough to win the eviction?
It's still going to be a tough call. I have seen judges, and to take a step backwards, no judge is going to want to make a decision on this case, because as the description sits right now, the harm to the children, the harm to the people hasn't happened yet. And the executive orders are talking about causing harm, or if the risk of harm is there, it's measurable. So we really don't know exactly what's happening with the dog. The sod and the grass, that might be, given the two, that might be the better way to go in terms of property damage. But with what's happening with the dog, and no, I don't doubt that the children are afraid of the dog. That's a real fear and absolutely should be considered. But it's really tough to say if nothing has happened, if we don't have a better sense of the dog's behavior.
Okay.
So one thing also that if there are these like tough call questions, is reaching out to the Attorney General and seeing if they think that this would fall under the moratorium, I think would be one step because it is just hard to tell, and like we're not referees, so we wouldn't be able to actually make those judgments.
And they've just done so much volume on these questions all year, well, over a year now. Next one's for you, Leah, from Anne. What if the landlord is trying to apply for assistance funds and the tenant has to sign off an application and refuses, saying they don't financially need and just don't want to pay?
Well, that's very frustrating, first of all, but non-payment and refusal to comply with the rental assistance are not under the moratorium. So these would, I don't think you can evict just for that.
Yeah, and look, we talk to tenants all the time, and some tenants tell us that they're not going to pay. And it's in the tenant's best interest to pay. With the money that's being funneled from the federal government through the state, it's the tenant might not like the landlord, might think the landlord's to blame for everything in the world, might not want to pay the landlord. But the tenant, and we explain this to tenants all the time, you're better off getting the rent paid, even if you're using this federal program that maybe you're opposed to the federal program for some political reasons, because you're going to have this debt follow you around. True, the landlord can't evict you right now, but that doesn't mean they can't sue you for money. That doesn't mean they can't turn it over to a collection agency. That doesn't mean they won't be able to evict you later if you're still around. So trying to qualify for the federal money is in the tenant's best interest. They might not realize that. And so one thing I'd tell a landlord is, hey, tell your tenant if they don't want to get the money to call somebody like us, and we'll try to talk them into applying for the money because it's absolutely in their best interest. Last question that I have on most of the things we've talked about. Andrea from Anonymous, can landlords charge increasing late fees every month based on total accrued unpaid rent, or are they limited to the same 8% amount each month based on only 1 month of unpaid rent? So I think I understand the question. So let's say the rent's $1,000. Tenant didn't pay January's rent. So then they'd owe $1,018. So then they don't pay February's rent on time. So they owe another $1,000, so up to $2,018, plus the February late rent would be $2,036. But can you get 8% on top of the 18 from January? I think is what they're asking.
It's my understanding that you can only charge the 8% on the rent for 1 month, because otherwise you're going to be charging more than the statute. The statute limits a late fee to 8%. And it's my understanding that you can't charge late fees such that the amount that you're charging is more than that 8%. That's my understanding. So it's literally that they can only charge that 8% on that 1 month's rent amount.
Yep. I agree with that too. Leah
Yeah.
from Anonymous, back to the irresponsible or malicious. Could irresponsible or malicious conduct be included in significant damage to property and resident endangerment if a tenant is allowing a dog to use the apartment as its potty place, damaging the apartment carpet and vinyl? Odors are awful, affecting tenant allergies, malicious treatment of the animal. So I do want to take a step back here. We talked about irresponsible, malicious, and willful. That's not in the executive order. Those words are not in the executive order. We have seriously endangering others, and we have significant property damage. It's just one way that judges are trying to find more usable words from state law. But just looking at the damage that they are alleging here, that the dog is going to the bathroom everywhere in the property, would that be, have you seen any cases like that where
I
pet
actually
damage
have, yes,
was enough?
pet
Yeah.
damage, specifically pet bathroom odors, etc., have been considered significant damage.
Yeah. Okay. So one last thing I want to try to cover with our few remaining moments is the St. Paul ordinance. And you guys can chime in as much as you like. We got several questions about this. There was an injunction, the lamplighter case as it's known, in St. Paul, where St. Paul had passed a bunch of ordinances, tenant protection ordinances that went into effect on March 1 of this year. A federal judge has ruled them to be, well, has granted a temporary injunction against the city from enforcing that at this point on behalf of a group of landlords that sued. As I understand it, and Eric, you might have more information about this from your contacts with the city, that they are considering their next step litigation-wise on how to proceed, whether they're going to appeal or simply go on with the case. What have you heard?
Yeah, I may not have the most up-to-date information, but as of last week, I had heard that the city attorney was, making that decision and in communication with city staff about what they might do. So I don't have any news on that, but I think, yeah, for the current time period, the court case, the preliminary injunction order means that the city cannot enforce that provision of the that ordinance. I think it's section 135.
So in effect, right now, that ordinance doesn't really have the teeth that it did at the beginning of March, but that case isn't finalized yet either. It's simply a temporary injunction ordered mid-case is all we have at present.
That's
Yep,
correct.
it's on hold.
Yeah.
That's the best way to describe it.
The
that-
rule is paused. Would that be
Yep.
a fair way to say it, Andrea? Okay.
Yep, it's paused. The case isn't over yet. But for the time being, a judge has said that for the time being, the ordinance is not in effect.
Okay. Got one last comment that came in from Anne. She says, we will lose lots of small landlords because they can't afford their mortgages of their one property or two properties they own. I think smaller landlords will be less likely to want to continue. Look, there's no question, Anne, that we've seen a lot of landlords that have struggled with this. And I think that the smaller the landlord, the more impactful it is. If one tenant doesn't pay their rent in a 100-unit building, the landlord can probably weather that. But if one tenant doesn't pay their rent in a duplex, that's got a huge impact on the landlord, which is why we're trying to encourage, and maybe you can go back to this slide, Eric, tenants to apply for the rental assistance through the federal government. It's not just going to help tenants. This will help landlords, especially those small landlords who are on the margins. And our hope is that once everybody's made whole through this money, and this isn't the last wave of money, there's already another wave of money that's been approved. It's not part of this round of programming, that it will settle up the debt for as many tenants as possible, which means landlords are getting paid too. And so hopefully that's what's going to happen, is tenants aren't just helped, but landlords as well. I think that's it for our questions. That was a lot.
Yeah, I was going to make two last comments unless you had anything, Mike. So there was also a chat, something in the chat about that sometimes the Attorney General's office will refer folks to Homeline or Legal Aid, and that might be coming from a landlord. And obviously we can't advise landlords, which we can provide this kind of general information. But I do want to just raise that our last session in early April 14th, we did have on somebody from Legal Corps they have a new advice clinic for low-income landlords. So I'm going to put that information in the chat because there are some legal resources available for landlords who might be low income. And so that's that. And then the last thing I wanted to say is, again, just a huge thank you to Leah and Andrea for all the work that was put in on this. Leah did a ton of legal research, reviewing cases. So send in your hand clap emojis over the chat.
Yay, Leah. Great job.
And again, our next sessions will be, the next one will be May 12th. And everybody who attended today will get a follow-up email with both the recording, the materials, the slides, some other resources that we got from Larry McDonough today and over the chat. And then also, what was the last thing?
The CLE code. We'll send that when we have
the CLE
it. Yeah.
code once it's approved. Thank you, everybody. Appreciate it. Have a good rest of your Wednesday.